filed 23-8997 Counsel, you want to place your appearances on the record, beginning with plaintiff's counsel?
Morning, Judge Westcombe, on behalf of plaintiff.
And good morning, Your Honor. Eric Stein on behalf of the defendant.
All right. Good morning. And this is the defendant's motion to dismiss. I've reviewed the motion and then the response. Go ahead, Mr. Stein, with your motion, sir.
Thank you. This morning, Your Honor, we have a motion to dismiss up pursuant to MCR 2.202A1B. I know that's a mouthful. In any event, I believe that the issue has been well pled, in terms of our brief and our motion. And so I'm happy to take any questions that the court may have regarding its content.
Well, if you could maybe articulate, I know the case law doesn't require a showing of prejudice, but is there any prejudice to the late substitution or any possible prejudice you'd want to articulate on the record?
So, Your Honor, the only basis I think for prejudice in this event is that we are talking now 5 years after the date of loss. The accident occurred in the year, I think, 2020, and the case was filed a couple of days before the statute of limitations expired. And now, because of the delays caused with the death and then the proper substitution of the parties, we are now 5 years beyond that accident date, which of course makes it difficult to locate witnesses, recollections fade. And, so we would argue that just that pure, the elapse of time that goes by here is a sufficient prejudice to warrant dismissal.
Okay, thank you. Mr. Compton, plaintiff's response?
Yes, Judge. I mean, we'd rely on the response. Essentially, I think, as you indicated, the statute may not require it, but you're inquiring as to the prejudice. We don't believe that there is. We've been litigating the case. We've been dealing with this issue with getting the estate open, which we did. Honestly, I appeared before you at the last hearing, and that was taken care of. It seems as if the substitution just didn't go in, the changing of the actual party. But, I work with Mr. Stein a lot. I don't think that we're not going to be able to get it across the finish line, but I obviously think it would be extraordinarily prejudicial to us to have the case dismissed.
Well, let me ask you, I mean, when you said that this estate had been opened, we did then double check that, and we're now past 91 days from the estate being opened. So even if I were to excuse the 91-day period from the notice of death, why on earth have you not substituted in the estate when it's 91 days after the estate has been opened?
Yes, Judge, that's where I mean it, for lack of a better response, it seems like the meat of it is that getting the estate open. The simple part is the substitution of the estate. And I don't know I don't have an excuse for you, Judge. I really don't, other than, I mean, I remember arguing it. Me and Mr. Stein talked afterward. In fact, we were doing that last hearing and Mr. Stein was in the waiting room, and he didn't get on the record. I mean, we had just spoke about it, and I don't understand. I am not the lead counsel on it. I did appear at the hearing. That's why I'm here. But Ms. Shanta was informed of it, and apparently the substitution we didn't get the stip over. That's my understanding. And I don't really have I wish I could say more, but I mean, that's really the issue. It looks like we did get the probate stuff done. We just didn't get it substituted over.
Okay. All right. Thank you. Any rebuttal argument, Mr. Stein?
No, I have nothing to add. Thank you.
All right. Well, in this is a third-party auto negligence claim. There was an uninsured motorist and underinsured motorist claim against an insurer that is settled, and now we only have the third-party claim remaining. This case was, as of today, it's been open 782 days. It's the oldest case on my docket. The complaint was filed October 3rd of 2023, more than 2 years ago. The defendant, who was alleged to have been negligent in the motor vehicle accident, died in January of this year. Now 11 months, almost 11 months ago, 10 months ago. A notice of the death was filed over 7 months ago. And as I said, it's been more than 91 days since the estate was opened. MCR 2.202 sub A1B provides that unless a motion for substitution is made within 91 days of the notice of death, the action must be dismissed as to the deceased party unless the party seeking substitution shows that there would be no prejudice to any other party from allowing later substitution. And the Court of Appeals held in the Bradley case cited by a defendant that even if no prejudice is shown, the court may exercise its discretion to dismiss the action. Here, the defense alleges that there may be some prejudice due to the passage of time in securing or the testimony of witnesses, because it's been 5 years since the accident. I'm not sure that there's a real strong showing of prejudice here. I mean, the defendant is a witness and she's passed away, but I presume her testimony has been preserved through some deposition. But there's no prejudice that would need to be required in order to dismiss it. The court rule says it must be dismissed unless there's a showing of no prejudice, and even then it's discretionary. Here, the plaintiff's response to the motion misses the mark, cites 2.313 as if this is a discovery sanction, and urges the court not to impose the harsh remedy of dismissal as a discovery sanction because there's no bad faith or history of sanctions. And that entirely misses the mark. I'm just perplexed by plaintiff's counsel action in this case. As I said, it's my oldest case. It's 2 years old, 7 months since a notice of death. And even if I overlook that, even if I gave the grace of saying, once the estate was open, we're going to restart the 91 days, and we're past that with no reason whatsoever. It would have been either a STIP or not, or if it's not approved by a STIP, as is referenced in plaintiff's response, file a motion for substitution under the court rule. The plaintiff's response doesn't even cite the appropriate court rule. I think on the whole, given the length of time, the delay has been pretty dilatory here. I'm reluctant to do so, but I think it is a proper exercise of the court's discretion to grant the motion and dismiss this case. So, Mr. Stein, you can submit an order to that effect.
Yes, I will do that. Thank you.
Okay, thank you all. Have a good day.
Thank you, you too.